Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me on this Legal Friday broadcast of The Bullet, as he does every time we talk about legal issues, well, most times we talk about legal issues, is Alex Ooley of the Ooley Law Offices in Indiana. Alex, and I always forget to do this, you also have a training company. You want to go ahead and plug that at the front of the show instead of the end of the show this time?
Yeah, sure. So, as you mentioned, I'm an attorney, but I'm also a firearms instructor, along with my brother and my parents. We have a training business, O2 Gun Group, at o2gungroup.com. We teach basic handgun training, but my dad and I are both attorneys, and we also teach a 5-hour legal class about the lawful use of force and self defense. So that's a good course for folks. We think it's the sort of the bare minimum, the essentials that people need to know to exercise their rights responsibly and lawfully.
All right, very cool. As I get social media hooked up here, I want to remind everybody if you want to comment on any of the topics we're going to be talking about today, we'll get your comment in and we'll discuss it on the air. And also, if you're watching on the Polite Society podcast, either Facebook or YouTube feed, you can comment on live video. If you're catching us anywhere else, go to Twitter, tweet with the hashtag the bullet. That actually gets to us the fastest. Alex, I want to first bring up there over the past few weeks since we've had a legal edition of the Bullet, we've had stories coming out of ATF agents going to individual houses. In one case, the person had bought in 5 or 6 guns over 5 or 6 months, and they wanted to make sure this person wasn't straw purchasing and made them produce one of the guns they purchased. They've also had reports of people that have bought triggers that the ATF doesn't necessarily like, but the triggers themselves haven't been declared illegal yet. There's ATF agents showing up along with state patrol at people's houses. First thing I want to say as we get started, when we speak, there's certainly on my end and on your end as well, but Alex, you don't know laws everywhere in the nation, so we cannot be giving legal advice. Nothing we're saying should be considered legal advice. If you need legal advice, get an attorney in your jurisdiction, right?
That's exactly right. Yeah, this is for entertainment and educational purposes only. It's not legal advice. There's no attorney-client relationship as a result of anything we say here. So definitely seek out advice in your own jurisdiction from an attorney who's licensed to practice there if you have questions regarding the law.
Absolutely. So let's get back to the ATF has been showing up and not a ton. I know of 8 or 10 instances that have been reported in the media. They've been showing up looking for people who may be straw purchasing or maybe looking for triggers that they may disagree with but haven't been declared illegal yet. Somebody knocks on your door, they announce ATF. Do you comply? Do you tell them go get a warrant? What do you do?
Yeah, so this has been in on a lot of people's minds recently, and in fact, I know some people who have been affected by this exact question. So, one thing that I always tell people is, uh, you have your rights for a reason, and you should exercise those rights, and that includes the Fourth Amendment, the right to be free from unreasonable search and seizure without, except by warrant supported by probable cause, and then also the right to remain silent under the Fifth Amendment, the right to be free from self-incrimination. So don't talk to the police. That includes the ATF. Don't talk to law enforcement. If they show up at your door without a warrant, don't simply let them in. And say that, I'm going to remain silent. I'll talk to you. I'll comply or I'll cooperate once I've had the opportunity to speak with my attorney. And if they come back with a warrant, you don't have much of a choice. The challenge is going to come at a later date for you to challenge the warrant and the byproducts of that warrant. So don't cooperate. Don't talk. A lot of people think they can talk themselves out of trouble, but more often than not, people talk themselves into trouble.
Yes, I've heard that time and again, and from law enforcement. I've heard that
Yes.
time and again.
Yes. One thing that, and this is not related to the ATF, but law enforcement officers, after they are involved in a shooting, they are instructed, they are trained to remain silent, because one thing that they know after a critical incident is that people uh, don't have good memory of things until several sleep cycles later. But it's to protect the law enforcement officer from potential legal liability in that instance. And obviously, these ATF investigations, or when ATF officers show up at the door, it's not the same as a self defense incident, but nevertheless, you're likely to have an elevated heart rate. You're likely to suffer from many of the same physiological effects that you would suffer from in a self defense incident, based on the ATF having showed up at your door. So be careful about what you say. Don't talk to the officers or the ATF agents that show up at your door. Make them come back with a warrant. And when they do come back with a warrant, they're going to search, and they're going to get into your gun safe more than likely. And I would not open it for them, because if you open it for them, that could be later argued that you consented to them getting into your gun safe. So I would, they're likely going to tear it up, likely to destroy it, and you won't be entitled to any uh, compensation for that. But nevertheless, do not consent. Do not let them into your safe, and do not
Well,
let them into your home without a warrant.
that somewhere between $600 and $7,000 will be satisfaction in them knowing they got to put a lot of work to get into that puppy. It's the more work they have to do. I mean that'd be money well spent on my part. I mean, just
Yeah,
to annoy them and make them have to work to get into a gun safe. Yeah, I'm good with that.
right.
So yeah, the other yeah, and I mean, of course, I'm gonna every once in a while we still get, and I get it in comments. I just never put on the air. Cold dead hands. They better send a lot of people and make sure that they don't have families. Well, that kind of bravado. Look, most of these people are just people doing their jobs. Admittedly, there are a few that are stretching it to the extreme, but is this something you really want? You really want to die over? Because
Right.
let's face it, all laws at one point are enforced at the point of a gun, and so if they show up and they do have a warrant, they're let them do what they're going to do. Just you don't have to make it easy.
Right. Yeah. Don't get in the way. Don't do anything that could be seen as resisting, because that could result in um, other or additional charges, and it could put you in danger for your life, for
Yes.
officers that are overzealous, or um, use excessive force, because we've seen that a few times. So if they come to your door with a warrant, don't die the hero's death over a few firearms or a trigger, or whatever. So we want to fight the fight in the courts at a later date, when that ensures your survival.
Well, and the good news is with the decisions, and we always refer back to this when you and I talk with the New York State Rifle and Pistol Association versus Bruin decision that came out in June. You're more likely now than ever when you get into that lengthy court fight to win. And so certainly you don't want to throw it all away if they do come knocking at your door with a warrant. You don't, you get a really good attorney, and open plug right now. I'm not paid for this, but I recommend being a part of Armed Citizens Legal Defense Network, simply because they have an extensive list of attorneys that are experienced in self-defense law. Now, that doesn't necessarily mean gun law, but the two are fairly close. So if you're a member of ACLDN, I would imagine they would willingly give you the names of the attorneys that are in your area, even if it isn't a self-defense case, even if it's a trigger case or whatever. Those same attorneys, while ACLDN may not pay for it, those same attorneys are going to be experienced, and you know where you want to go to get a good one.
Yeah, and the good thing about that network of attorneys is that even if they are self-defense attorneys and not gun law attorneys, often they'll have some insight or be able to point you to someone who can help you with a gun law issue. It's not necessarily a self-defense issue.
Yeah. Well, and let's. We've mentioned this. I think it's been a long time, but we've mentioned this before. Lawyers are a little bit like doctors. You have heart doctors, you have brain doctors. I have a diabetes doctor. That I have a lot of different doctors after my health problems last year, but there are attorneys that specialize in self-defense, criminal law, family law, and if you've got a legal license that allows you to practice in a lot of different areas, there's a specialization that you want to look for when you're looking for an attorney as well, right?
Yeah, that's exactly right. I'm from a small town, and particularly in small towns, it used to be the case that if you were an attorney, you did a little bit of everything. But that's not the case so much anymore, even in small towns, because the law has gotten so complicated. It's far more complicated than it was 50 years ago or even 25 years ago. And the same with medicine. Medicine's more advanced, more complicated. So attorneys are forced, if they want to be competent and want to be good, they're sort of forced to specialize in a particular area of the law. So you want to make sure you find somebody uh, who knows what they're talking about and is very familiar with their particular area of practice.
Very cool. Let's. I do want some. There's some legal stories that came out this week that I want to talk about. This one coming off theweek.com. Just a little. I'm going to read just a little bit of this story. The Ninth U.S. Circuit Court of Appeals has vacated a May decision that deemed California's ban on selling semi-automatic weapons to adults under 21 to be unconstitutional, citing recent Supreme Court ruling New York State Rifle and Pistol Association versus Bruin. The court has now sent the case back to the federal judge who refused to block the ban from 2019 when a 19-year-old opened fire in a synagogue near San Diego. In June, the High Court ruled it was unconstitutional to require a license to carry a concealed weapon. Well, that's not quite accurate. And said firearms restrictions not rooted in the history are in violation of the Second Amendment, the Los Angeles Times reports. As a result, California's attorneys argued that the May case needed to be remanded or sent back to the lower courts for both parties to provide more evidence and historical content to determine the ban's constitutionality. The Ninth Circuit granted the remand without providing an explanation or new conclusions regarding the ban's constitutionality. Alex, we've discussed Bruin every time you've been on since the decision. The Ninth Circuit, these are justices. They ought to know this thing backwards and forwards. Is there a reason? I mean, is there a legal reason why they just didn't say, "Look, the Supreme Court stated this is wrong. It's wrong," and just reverse it rather than just sending it back to the lower court to be argued again?
Yeah, so we talked about this a little bit a couple weeks ago in some other cases, and I think this is simply a tactic to delay an inevitable outcome, and that is an outcome in favor of individual liberty and the Second Amendment. And the state, the attorneys for the state in these sorts of cases argue that, well, we didn't argue the case initially under the standard set by Bruin because Bruin hadn't been decided yet. So we need to have an opportunity to develop the history, develop an argument around the text, history, and tradition standard before the Ninth Circuit can make a decision. And we didn't get an opportunity to do that before, so court, please send it back down to the district court, to the trial court, so that we have an opportunity to do that. But while that may be some justification, I think it's primarily uh, an excuse to delay an outcome that's against the state of California.
Um, when I had Amanda Suffocool on 2 weeks ago, she floated the idea that the smaller the court, the smaller the precedent, the smaller the footprint of the decision. I'm wondering if that might be something that's here too. If it's decided in a California lower court, then it's just a California decision. If it's decided in the Ninth Circuit, it covers California, Hawaii, Alaska, uh, Oregon, Washington, and the territories, the Pacific Island territories.
Yeah, I think that's true to a certain extent, except that these issues are likely to be decided by the Ninth Circuit eventually, and maybe beyond that, the Supreme Court. So that precedent at the lower court, the smaller footprint precedent that she's talking about, would only exist for a short period of time, and maybe they're trying to buy time until the composition of the Supreme Court changes. I don't know. I can only speculate in that regard.
Sure.
But that hopefully is a long way down the road.
Uh, Michael, we're talking about specialization and lawyers and specialization and doctors. They charge more than doctors. Well, I imagine a good. I imagine a good lawyer probably would. And let's face it, the amount of training, you've got to have to be an attorney is right up there. I believe just like a doctor is. You've got to have first. I believe. Well, I'm not going to just talk out my backside. What does it take after you have to go get a 4-year degree and then you have to go to a law school after that, right?
Right.
And then you've got
years.
to pass the bar.
Right.
So
yeah, there's some significant hurdles there, and some attorneys do charge a lot, but some doctors charge a lot as well. It depends on the specialization. If you've got a neurosurgeon or some high level heart doctor, I think an attorney would be hard pressed to charge as much as they would.
Well, I'll say this: I know what my insurance company paid for the vascular surgeon when this happened. That for one surgery that took less than, I mean, it was a morning thing. It was a few hours for the surgeon. I was in the hospital for a few days, but for a few hours for the surgeon, it was more than I made in a year and a half. So yeah. I don't know what his portion of it was, but the total bill was almost enough to give me another heart attack.
I always tell people to avoid court if at all possible, and likewise to avoid the doctor if at all possible, because it is so expensive and such a burden, not only monetarily but emotionally too. So don't get in trouble with either self-defense wise or over an item that you've purchased. If it's a trigger or an AR pistol or whatever, you can replace those. You can't replace yourself, and you can't get time back that you might have to spend in prison.
We're going to have a fight coming up about that, and we'll be discussing that tomorrow on the weekend edition of The Bullet. Apparently, the ATF is getting set to declare anybody that put a brace on their AR pistol now has a short-barreled rifle, and oh, by the way, you've got to pay a tax stamp on that now. And we'll be talking about that tomorrow. I don't have the prep done for it today, but yeah, that's a topic we're going to be talking about. So I do want to let's skip to the next one we have here for today, though. This one off BloombergLaw.com, and ironic that Bloomberg actually is providing me information, but U.S. District Judge Glenn Sotheby denied a request last week to stop the law, speaking of the New York concealed carry law that took effect on September 1st from taking effect. His 78-page decision described at length why the law could be found unconstitutional. Among his reasons for that, the new law omitted the phrase other than in self-defense, which could create a Second Amendment problem. The state's list of prohibited places is extensive, and automatically declaring private property a restricted location usurps private property rights. The law's social media and character reference requirements grant too much discretion to licensing officers and risk punishment for political speech in violation of the First Amendment. Fifth Amendment concerns stem from an applicant having to incriminate themselves by providing all the information required for the permit. I know you've got too much going on to catch every day, but when I had Matt Mallory on last Thursday, and that was the day after this decision was released, this particular federal judge resigned the afternoon, or was replaced, and I don't know if he was resigned or he was fired, but I know he left office that afternoon and was replaced by another judge. Yet that evening, he still ruled in this case. That to me, just there's something that smells strange there, but I don't know if there's anything legal behind that or not.
Yeah, I'm not sure how to read into that. But I'm like you. That sounds fishy, and doesn't seem right. So I'm not sure what the circumstances were there. They could have been completely innocent, but I'm skeptical.
Yeah, if you're going to retire, I don't know. You would think you would leave the decision for the next anyway.
Right.
Yeah, but anyway, all the reasons in his all these reasons I agree with that there are a lot. There are each of these reasons are a law that New York State carry law should be smacked around. And I mean, Alex, I honestly, just between you and me, not just that, don't worry about anybody listening in on us, but I personally believe eventually, especially if we were able to keep this court for several more years, we're going to get to the point where it's not only going to be, it's going to be real shall issue throughout the nation, in that that they have the ability to say you can get you have to get a permit, but they cannot say who is going to get that permit other than you submit your paperwork. If you qualify, you're done.
Right. And that's what's so problematic about this law from New York, this part about the law's social media and character reference requirements. And the judge says those requirements grant too much discretion to the licensing officers. So this is clearly not an objective standard like should be like should exist in a shall issue state. These good moral character requirements give way too much discretion to bureaucrats to deny people their right to keep and bear arms. And this is just a workaround the Supreme Court's decision. And I think ultimately it will get struck down. But nevertheless, like we've said before, we're going to have to fight this and spend money in the courts to get to where we need to be.
Yeah, absolutely. Let me go over to I want one more story. I think this is going to take up the rest of the time we have. We only got about 5 minutes left. This one off the Daily Signal. Jewish group to sue New York for banning guns in houses of worship. And the New York State, I'm just going to read a little bit of it. The New York State Jewish Club plans to sue New York for banning firearms in places of worship, calling it unconstitutional, in an interview with the Daily Caller News Foundation. Wow, this is a name. Tzvi, Tzvi Waldman, the founder of the New York State Jewish Gun Club, is working with a civil rights attorney to challenge a provision of New York's new Concealed Carry Improvement Act prohibiting congregants from carrying guns inside places of worship, among other locations it deems sensitive. Well, and here we go right back to sensitive places. and private property rights, Alex, a church is private property that the church itself owns. It should it seems the church should be able to decide what is allowed and what is not allowed on that property.
Yeah, I agree. So not only is it infringing on the Second Amendment, it's infringing the private property owner's right to maintain and control the property as they see fit. So I think that prohibitions like these are uh, unconstitutional. And it's another example of New York's law being so overbroad and overreaching. Their definition and the things that they include in sensitive places or sensitive locations is so exhaustive. We said before it would have been easier to make a list of places you could carry in New
Mm-hmm.
York. Their list of sensitive places was so long. So I thought it was interesting the uh, the article mentions that the average Orthodox Jew spends up to 20 hours a week in synagogue. So, I mean, they're spending a great deal of time on private property where the state of New York is saying you can't protect yourself. And I think that's just clearly overreaching. And this is another example of where the government says, okay, first we're going to take away your right to protect yourself. And oh, by the way, the police and law enforcement have no duty to protect you. The Supreme Court has said that. That's been the precedent for a long time. And I don't think I've ever said the name of the cases on the show, but I've got them handy here. DeShaney versus Winnebago and Town of Castle Rock versus Gonzalez. Those are the cases from the Supreme Court saying that police are not obligated to provide protection to individuals. So we're going to take away your right to protect yourself because you should rely on law enforcement to do that job for you, except that they have no duty to do that. So this is clearly, I think, a catch-22 and puts law-abiding citizens in danger and takes away their right to protect themselves.
Absolutely. I want to, on our way out here, let me check here just a second here. Let me go. I want to promote Gun Rights Policy Conference and AMCON on our way out, simply because they're fast approaching. AMCON, September 30th, Gun Rights Policy Conference. The evening of September 30th is a reception, and then October 1 and 2 is Gun Rights Policy Conference. Um, if you are in Second Amendment media or you want to be in Second Amendment media, you should be at AMCON. This is where everybody in Second Amendment media gets together. We discuss what's working, what's not working in Second Amendment media. We try to make everybody's media better. We have the best of, for example, Lloyd Bailey, who has the most tight audio production of any podcast that I know of, pro-gun, non-pro-gun, politics, whatever. Lloyd Bailey has the highest production value of audio of any podcast I know of, period. He's going to be speaking about audio production. Our keynote speaker is going to be AWR Hawkins. We've got other speakers. We've got a networking program that is just outrageous that's coming out at the beginning of it's a 2-hour networking. I call it networking on steroids, but it's directed networking. That is we're going to be trying out this year that I'm really excited about. And one last thing, we're going to be giving away a Taurus TX22 handgun to one of the attendees of AMCON. And so just if you're interested in becoming Second Amendment media or you're already in Second Amendment media, go to amcon.org and you can register right there. We do need you to register because the SAF needs to know how many lunches to buy. And I'll tell you right now, if you attend, we're capped at 100, so your chances are at least 1% or more. Well, more than, because the 100 includes me and I'm not eligible. The 100 includes Susan. She's not eligible to win the gun, but your chances are greater than 1 in 100 if you attend AMCON. that you're going to win a gun. So, and we've got other things that are going to be going on with AMCON. GRPC, if you're involved in gun rights at all, you need to be at GRPC. I discuss it a lot. It is simply, if you're making things happen in the Second Amendment, you're probably talking at GRPC, and when you're not talking, the public has a chance to come up and interact with you. And it's a phenomenal get together. That's October 1st and 2nd. You can register there by going to saf.org/GRPC. And I just blew all our time we had left, Alex. Anything you want to plug, bud?
Just real quickly, there was a lot of effort and energy over the last year and a half going into the effort to implement constitutional carry or permitless carry in states around the country, and then also with the Bruin decision, there was lots of anticipation of that. I just want to encourage people: don't be complacent. Don't rest on your rights. Get involved. Go to events like GRPC. Donate to organizations like Firearms Policy Coalition, Second Amendment Foundation, because the fight's not over. There's lots of litigation still pending, lots of important decisions that remain to be decided by the courts. And organizations that fight for freedom need your support. So whether it's a national organization like Second Amendment Foundation or a state organization, make sure you get involved. Here in Indiana, where I'm from, the 2A Project is an excellent organization to get involved in. So I would just encourage people to seek out a quality organization in your state and get involved and stay involved. Don't get complacent.
Absolutely, I totally agree with that. Two comments on the way out. Michael says there's only 7 states that are causing problems with May issue. New York City, and New Jersey and Hawaii are the worst. I think you're right. New Jersey is kind of, sort of complying a little bit. I'm fairly surprised in that Massachusetts and Maryland seem to be fully complying with the Bruin decision, and that kind of really surprised me. So, and then Roderick says, "I'll be at GRPC in Dallas." Roderick, make sure you come by the table where you'll see me. I'll be up somewhere up front behind a table and a whole stack of monitors. And I'll be producing the show, putting stuff up on the big screens. If you see me and I'm not actively pushing buttons and pulling what little left of my hair is out, just stop by and say hi. And that goes for not everybody, not just Roderick. I'd love to say hi to y'all. So, Alex, that's going to do it for us today, I think, man.
Sounds good. We'll see you tomorrow.
Absolutely. Yeah, do come join us tomorrow, 12 p.m. Central Time, for the weekend edition of the Bullet. We've got a lot more to discuss that didn't even make it to this one, plus more legal stuff that didn't make it to this one. Plus, we've got our week in the news wrap up. So that's it for us today, folks. We'll see you tomorrow, and thanks for watching.